Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case.
How do you know if your divorce qualifies as uncontested?
There's no way to know whether or not your case qualifies as uncontested. The only way to qualify whether it's uncontested or not is if the two parties actually agree. A lot of people will call and say, I have a completely uncontested divorce, but we don't agree on where the children are going to live. We don't agree who's going to pay child support, and I want to have all the assets. That's not uncontested. Uncontested in an attorney's eyes is somebody contacts you and says, hey, look, my spouse and I have decided that we're going to get divorced. We'd like to do it with just one attorney, which then we have to let them know we can't do it with just one attorney as far as representing you both. But if your spouse doesn't want to get an attorney, which we would advise him or her to get an attorney, but we can draft pleadings, we can assist you, meaning the client, in coming up with strategies and plans for implementing this agreement, whether it be for temporary orders or whether it be for a final actual decree. Uncontested could have various moving parts. You could have uncontested on the front end where, yeah, we're totally uncontested on the temporary orders. We know what we want. We're just not sure how we're going to finalize it. All the way to we have a full-blown agreement. It's going to be totally final. Please file my petition for divorce. Get a waiver for my spouse. The spouse signs the waiver. We get it back. We file it. You have to wait your 60 days from the date you filed to get your agreement entered with the court as final decree. And during that waiting period, we get the agreement. We draft up the final decree, and we get it entered with the court. Now, there are issues in the interim. Can you think of any things that sometimes occur while we're trying to get uncontested divorce solved?
Well, and I've often found that people will call and say they have an uncontested divorce and they've never even spoken to their spouse. They know what they want as far as all the terms and conditions and things like that. And so it does require that they've, had some communication with the other party so that they know what it is they're getting into. In the interim, between the time we're doing the original petition and waiting for that 60-day time clock to expire, there could be issues in regards to interim child support, who's paying the bills in the meantime, who's going to live in the residence, are we going to go ahead and put it on the market to sell, are we, who's going to be taking care of the day-to-day necessities for the children. So those are things in an uncontested divorce. If the parties have reached agreements for that, fantastic. But in contested divorces, that's typically what we use temporary orders for, so that we can put some of those orders in place to make sure that people can move forward on a day-to-day activity. So hopefully, if it is uncontested, they can agree on those issues and it not become a contested issue as we proceed.
Right, and I'll have people call in and say, well, what's ordinary? Every single case is a thumbprint. No one's case is alike. Nobody has the two same parties that are clones of them are getting divorced. Their children aren't the same. Their circumstances aren't the same, whether it's where their children go to school or how many children they have or their ages or, whether or not there's any medical issues with mom or dad or the children or financial things. Everything is a thumbprint. So when we do this, the number one thing that I think all people that are possibly going through a divorce or that are going through a divorce already, they need to make sure that they get an attorney that they feel comfortable with that can provide them sound advice on strategies on how to move forward, what to do, and not just, hey, hire me and I will win and I will get all your rights and you won't have to worry. There's always an ulterior motive, unfortunately, and we hear these things all the time. I can't tell you how many times I have clients call that say, gosh, I wish we would have found you at the very beginning, because that's not what we were told. One thing here at Turner Monahan that we're just not going to tell you what you want to hear. We're going to tell you what we believe is what's best for your circumstances. Sometimes that's a completely amicable resolution that you've come up with. Other times you might think it's a great resolution and we say, unfortunately, that's really not going to work, and we think XYZ should occur.
Yeah, it's often with uncontested divorces, parties want to just say, oh, we'll just do visitation as agreed, or we'll just agree upon these things as time progresses. Well, because of our years of experience, we've seen things like that fail so many times, and then it's impossible to enforce those kinds of things later on. So that's where typically having attorneys who are extremely experienced in these things can go, okay, here's the pitfall with that. Here's the problem. I know you're trying to all work together and do co-parenting and do those things, and you can, but there needs to be something more specific in your order as a default mechanism in case y'all get into a position where you don't agree in the future. And that's the piece of advice that comes with experienced family law attorneys that can help make sure that even in the uncontested divorce, where individuals are getting along, that they're protected on the back end in case something does go south somewhere down the line. Because oftentimes, and particularly when there's kiddos involved, that could be a very long period of time you're having to deal with the other spouse. So making sure you don't have to constantly come back into court is a strong benefit.
And so a couple of questions kind of come up as we were talking there. We talked about attorneys and how one attorney can't represent both. A lot of questions we see online is, my ex-spouse told me and his attorney can represent us as both. And so I know you mentioned no, they can't. So why can't they? And how can somebody about to go through a divorce talk to their ex to say, hey, I need my own attorney without it turning uncontested? So what's that conversation look like for them?
Well, it's impossible for us to know what's going to happen when you talk to your spouse and you let them know, hey, you can't use this attorney or we can't do this. But the main thing is it's a conflict of interest. There's no way for one attorney to represent both parties. You can't be speaking out of two sides of your mouth. You can't provide advice to one party and then go provide advice to the other party. In a divorce case, the only time that there can be a neutral person who is providing services to both parties would be a mediator. And that mediator cannot give advice. That mediator that is there to facilitate an agreement when hopefully both parties have attorneys to assist them with advice and assist them in getting an agreement. So I think the best way to approach your spouse, if they're worried about, well, I thought that the attorney could represent both of us, one of the things is that the attorney that one spouse hires, while they cannot provide advice to the other person, if there is an agreement, you want to make sure that when you're hiring an attorney, you're hiring an attorney who's listening to the desires and wants that you and your spouse are trying to get, and have an agreement drafted based upon that, but also listen to your attorney's advice on maybe this isn't the best way to implement that. Maybe we make this change and pivot here or pivot there to make sure that it's going to last for both of you in the future.
Mm-hmm. And I think one of the points that a spouse can make to the other about hiring an attorney is that it's in everybody's best interest for everybody to be protected so that nobody feels as if there was undue influence or somebody was manipulating a situation. The other party can always hire an attorney either to represent them throughout the divorce, or they can even hire an attorney just to review the final documents to make sure that what was discussed is what's actually represented in the final decree that would become the order of the parties. So there's lots of ways to go about it in a way that doesn't say, I'm hiring an attorney because we're going to start fighting to the death. But each party does need to have adequate advice and protection so that there's not a problem on the back end again.
And I think that kind of leads into the next question. Are there hidden risks about going uncontested?
Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to Behind the Case.
I guess there can be some hidden risks that in an uncontested divorce, but everything has risks, right? I guess the main risk is that you don't know what the judge is going to order if you had gone to trial. That's why whenever we do prove-ups, when there's agreements, you always say, and you understand that we're not having a trial here today, and you understand that you could have had a trial, and you're entering into this agreement, and that the judge could have ruled something completely different, maybe the same, but you want this agreement entered because this is your agreement that you have with your spouse. So I think the main risk would be what would have happened if I went to trial or temporary hearing or whatever it might be. Do you have anything different?
Yeah, and I also think with an uncontested divorce, you're putting your faith in each other. The spouses are putting faith in each other that they're being truthful about, for example, the financial circumstances. If you have a couple where one spouse has always handled the money and the other spouse has just kind of always just followed, there is a risk that there could be some assets that one spouse may not be aware of, and so they may not be fully divided, or it may not be divided appropriately, those kinds of things. So there is a leap of faith that is required in an uncontested divorce, in the fact that you just have to accept that you're both being truthful and honest and moving forward in the best way possible for their families.
And now one of the things that we always require, and I'm a stickler about, is having inventory and appraisements completed.
Absolutely.
Inventory appraisements is basically tell me what you own and what you owe. Each party fills out an inventory and appraisement in 95% of every single divorce case. Here, it's 100%. The reason being is they need to be sworn to, and so if the spouse won't do an inventory and appraisement and you do one, meaning your spouse is not represented, I have our client sign a waiver stating, I'm still going to agree to this, knowing they did not do an inventory and appraisement, and that there could be outstanding issues that I could be liable for that I may not know about, and the attorneys at Turner Monahan are not able to provide advice in regards to those because we can't get them to do an inventory and appraisement. So I think that if you do as much as you can on the front end, while this client might not think it's easy, everything that we do is trying to make sure that we're trying to cover our clients and make sure that they are covered whenever this gets finalized, especially if they're doing an agreement. I think the inventory and appraisement is something that has to be done if you're going to get into agreement, because then that can, if they didn't disclose something and you find out later, you could come back and file what's called post-divorce division of property suit. I don't want to get too deep in the weeds on that, but that's something that you can do. Good attorneys think about the future and not just what's going on there today to try and get a case finished.
Absolutely. It's not just the drafting of an original petition, a final decree, and a waiver when you're representing somebody on an uncontested divorce. Even though, oftentimes people think about it as being that easy, there are other steps and other things that we do as experienced attorneys to make sure that our client is protected in the future, and to make sure that we've covered everything that we possibly can cover for them and taking care of them in the best possible way.
And that kind of leads, you'd mentioned earlier kind of like children are involved, so it makes it a little bit harder. But also, money and assets. So when we go into uncontested, is everything always 50-50? No,
uncontested is just a term to say that I'm not going to go into court and argue. It could be split 60-40. It could be, the children's time could be split 60-40, 55-45. It's impossible to know what the division is going to be. There is no set division. The division is whatever the two parties agree that it's going to be, so long as the attorney or attorneys are okay with it being that way.
Mm-hmm. Yeah.
That's the way it is.
Yeah, if somebody comes to us with a 70-30 split, which is unusual and very lopsided, we would advise them that that's unusual and very lopsided. But if that's still what they want to do and they've been educated in regards to it, fine. But that's the whole premise of the uncontested divorce, is it's the parties reaching these agreements, us letting them know what's appropriate, what's not, what's allowed, what's not, and then us putting it into writing for them.
You find it beneficial for clients to have an uncontested divorce, or would you recommend them to be contested, kind of that side of it? And then what are those first steps if they're having an uncontested divorce?
I have never given someone advice to have either an uncontested or a contested divorce. The facts and the circumstances dictate whether or not it's uncontested or contested. I think the courts would all love if every case was uncontested and you never showed up there and the court was so quiet they could hear a pin drop. Honestly, the judges don't want to make a decision. They really don't. They want to leave that. Whenever people got divorced, I know when I got married, there was no judge standing there saying, I'm the judge for your divorce later on. Well, they probably don't need to be there saying, well, now I'm going to divorce you and I'm going to make decisions on everything you're going to do from this point going forward, all the way to your children, 18 years old, plus what's going to happen to all your assets and debts. So I think that most of the time, if the circumstances fit, we try to figure out a way to amicably resolve a case. That's why probably 97% of our cases are resolved amicably, whether it be just between the two parties without going to mediation or with the help of an unbiased mediator. I think that anytime people can make the decisions on their own about their children and their assets and debts, that's the best way to do it when the circumstances present themselves, which for the most part they do, unless there's just some unbelievable reason why there's no way to reach an agreement. It must go to trial.
I absolutely agree. It really is fact specific on whether it's contested or uncontested. If the parties have the right relationship and the right demeanor and the right mindset, it could absolutely be uncontested and it can absolutely be settled without the necessity of court intervention. And anytime you can finalize these things without the court making unilateral decisions, you're in a much better position, whether it's, helps not make the co-parenting relationship worse or, the division of the estate more difficult. It certainly is easier when you feel as if you're in control of the decisions about your children and your assets moving forward, as opposed to having this random third party who doesn't know you making these decisions. So we very much encourage amicable settlements as much as we possibly can, though we're absolutely not afraid of going to court and fighting for the benefits of our clients and things of that nature. But it is definitely easier if there can be an amicable agreement rather than a contested knockdown, drag-out trial.
And I think, I don't want to put words in your mouth, but I think when Tina says easier, we're meaning easier on the clients,
Yes.
not easier on us. And I tell our clients all the time, the more you fight, the more you pay us. Now, there are times to fight,
Absolutely.
but if there are workarounds or if there are other alternatives to fighting that fit, maybe not perfect, but that everybody can live with, we are always going to try to look at that side of the coin and at least provide that advice to our client. We are navigators, our clients are the captains of the ship. We're the ones who say, watch out for these icebergs here. You may not want to go 100% full steam ahead in the middle of the night. If they decide to do that, that's what they decide to do. We can only provide them the advice, which is much like what a navigator does to the captain of a ship. That's the way we look at it.
And what's the first step somebody going through uncontested divorce should take?
Contact Turner Monahan. Or if you have an attorney that you've used in the past and you have an attorney that you feel comfortable with, that's what you need to do. I always tell people, you need to find an attorney that you're comfortable with. If somebody calls and they just say, I'm not that comfortable, I'm not going to try to fit a square peg into a round hole. I want our clients to feel comfortable with us because, as we talked about earlier with Mackenzie, it's about setting expectations up front. And if you can set those expectations, if people feel comfortable, generally things are going to work out the way that they should. And it's going to be easier for the client. They're already having a difficult time emotionally, logically. It's a very difficult time for people to go through because you're talking about their entire world. So that's tough.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com. That's TUMOLAW.com or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.